Hello, everybody. Buenos dias a todos. Welcome, everybody, to this training on the changes to the FAR contract. It's great to have you all here. We are oversubscribed. There's more than 100 people signed up for the webinar, so we are also going to be transmitting live through Facebook. So it's a great turnout. We're going to give people a few more minutes as they're coming in, okay? Welcome, everyone. On our computer. Can you guys hear me okay? Let me know in the chat if you guys can hear us and see our screens. And we have a couple more people that are joining, so we're going to get started in a few minutes. Excellent. Great to see some familiar faces and great to see some new friends joining. We're going to have a packed house today. It's going to be a great session. Hopefully, this is going to be a great opportunity for you guys to share with your clients as well. And you know, the clients always want to make sure that their realtors are as up to date as possible on their trainings. So this is a great moment to be sharing with your clients. All right, well, we'll start in 1 more minute as everybody gets settled in. Today's session is going to be in English. As you probably know, we're going to have a Spanish language session next week. So if you want to sign up for the Spanish language session, you still have time. Today, luckily, we were oversubscribed. There's more people subscribed, more people wanting to join than can join. So we're live streaming it on Facebook Live as well. Okay. All right, it's 11:05, so we're going to get going. Good morning, everybody. Thank you very much for joining us this morning on this very important session where we want to share with you the changes to the FAR as is contract that were implemented that will be implemented in a few days. I have the great pleasure and honor of being joined today by my partner and attorney extraordinaire, Nelson Taracido, who's the CEO and co-founder of FOLIO. Welcome, Nelson.
Thank you, Ricky.
Nelson's been doing this for a long time, and I've been lucky enough to have been mentored by Nelson, and we have advised thousands of realtors, clients, investors, sellers, on the provisions of the contract, helping guide them through to use the contract to reach win-win negotiations. So today, what we're going to be doing is going through some of the changes. I invite you all to share the experience on social networks. You know, I know your clients want to know that you guys are always up to date. You guys could tag us at foliotitle.com on Instagram, tag yourselves, tag your brokers. This is a great opportunity to show that you're doing everything you can to stay up to date. So what we're going to do today is essentially talk a little bit about the changes to the as-is form. These are the first major changes that have been done since 2017. Usually there are updates every 2 years. It's important for you to know where these updates are coming from, right? The as-is contract is the property of the joint committee between the Florida Realtors Association and the Florida Bar Association, of which Nelson is a member of the Florida Bar. Most of you are members of Florida Realtors. These are changes that are going into effect on Monday, November 1st. So they are very current. So make sure your brokers have the latest forms, okay?
That should be automatically done for those of you at Avanti way. But yeah, using the latest forms is always helpful. Some of these changes are generated by sometimes tension in transactions, areas of ambiguity that these governing bodies want to, the Florida Bar and the Florida Realtors want to try to simplify and help, the clients in their closing process and make things as, smoother when they can.
And this change has quite a few revisions that we're gonna go through today, notably in the financing provision, in the delivery methods. What we have tried to do is we've tried to prioritize what we think are the most important changes. We're gonna try and get through all of them. We think we're gonna be here about an hour or so, little more, little less, but we're actually gonna skip around a little bit because we wanna take you through what we think we need to highlight. Now we're gonna start with the financing provision in paragraph 8. Essentially, in the financing paragraph, we have the change to 8A, very simple change. They simply, they simplify the language. Basically, this is a cash transaction with no financing contingency.
Yeah, before it got into a little bit of, you could still get a loan, but there's no contingency, all of these, just, it was very wordy, as you could see, it was 4.5, 5 lines long. And now they made it a very simple sentence, which basically says the same thing. Just because you check off 8A doesn't mean you can't get a loan. Just if you can't get a loan, you can't cancel the deal because of that. That's really the only thing that's happening there. So it's a very simple and straightforward concept. It's a cash deal, there's no contingency. However, you could still choose to get financing if you want to.
The bigger changes have to do with the financing paragraph 8B, okay? That basically now has 2 tasks to be completed to qualify for loan approval, and those tasks need to be done during the loan approval period.
Correct. Yeah. Obviously, we always wanted to get a loan approval during the loan approval period before. The difference was, in the older version, your appraisal could lag that and it could come in after the loan approval period. And many times you saw a lot of lawyers on the seller side change it to what's currently being, used now by the Florida Bar and Florida Realtors, basically saying, look, everything needs to be done during the loan approval period, including the appraisal. And that's a very important point to consider when you're representing buyers, because it is absolutely imperative that appraisal comes in. Otherwise, you don't have a full loan approval.
Correct. So in addition, now if you include the sale buyer's property as a contingency, the rider V, basically the loan approval is good if rider V is included.
That's correct. Basically, the loan approval that comes in with a sale of buyer's property, it's only valid, this condition, if rider V is attached to the contract. So if that's something going into a transaction that your buyer absolutely needs to sell their home in order to qualify for this new loan, then rider V has to be included when you make the offer with the, on the initial contract.
Now, Nelson, because of the tight market, we have seen several cases in the last couple of months where buyers must sell their property to purchase another property, yet because they don't want to lose out on the deal, they are not explicitly not including the rider V, even though the realtors are informing them, hopefully in writing by email, that it is advisable to include rider V.
Yeah, and that's a business decision by the buyer, right? The buyer wants to strengthen their offer by not providing rider V. Again, what they're putting themselves at risk, because if they're not able to sell their home, they won't be protected by the financing contingency in this new format. And so if they're unable to sell their home, they're going to lose their deposit. If they're comfortable with taking that risk, then obviously, like I said, that's a business decision they make. They want to make a stronger offer. They don't include the contingency as stated here. And if they're unable to sell their home, then they either have to renegotiate with the seller and maybe get some more time to sell their home. Or like I said, if it doesn't go anywhere, they're at risk of losing their deposit.
Another change is that before, the buyer had to promptly notify the seller of their loan approval. Now the buyer is able to use the entire period
Yes.
of the loan approval.
And there's some important changes with this communication that's happening at the end of the loan approval period, because, and we're gonna see it in further slides. You have to, and as realtors, you really have to focus on this. You have to communicate with the other side what's happening. If you have a loan approval, you have to communicate it before the end of the loan approval period, because if you don't communicate it before the loan approval period, your seller can cancel the transaction. And so that's something, and we're going to look into that on a forthcoming slide. But right now, if you have a loan approval and you're within the loan approval period, you have to communicate that to the other side.
writing.
In writing, absolutely, everything in writing. And if you don't have to do it as soon as you get the loan approval, as it used to say before, but it has to be done during the period, before the end of the period. So, and the other, and here's the next paragraph. If you're unable to obtain the loan approval within the loan approval period, then the buyer has some options. One option for the buyer is to proceed. And, if they feel comfortable that they're able to close without the loan approval or without a loan, or however they feel comfortable, then they can proceed and go to closing. However, if that's the choice they're going to make, they need to make sure that they communicate to the seller that they're waiving their financing contingency. Because like I stated previously, if you communicate nothing to the seller has the option to cancel the transaction for a few days after the loan approval period. And so it's important that if the buyer is planning to proceed with the transaction, even though they don't have a loan approval, that financing contingency gets waived, so that the seller has no more ability to cancel the transaction. Now, obviously, in many cases, if the buyer is unable to find a loan approval during the loan approval period, and they're unable to proceed, then they need to cancel, and that communication, should happen within the loan approval period. It needs to be communicated to the seller. Hey, we exercised good faith. We were unable to get our loan approval during this time. We need to back out of the deal and, get our deposit back.
This is very important for you as realtors to consider in the time frames of the contract. Many times you foresee that we will need more time, not just for the loan approval, but for the closing. And maybe the bank has communicated to you that not all the conditions have been fulfilled. And so realtors execute extensions of closing dates without simultaneously executing extensions of the loan approval period. And this really puts at risk your buyer's deposit. And in my conversations with realtors, which, I'm on the phone most of the day with them speaking about these kinds of things, many times they're like, oh, no, but the listing agent knows that it's because we need more time for the loan, right? I think that more and more, we want to see realtors adopt the most up-to-date standard professional practices in the industry. When you have verbal agreements, these are not going to protect your buyer and seller. Even if the listing agent accepts verbally that they were in agreement with extending the loan approval, maybe the seller wants to back out, or maybe the seller wants to sell it to someone else. And if it's not in writing, in that case, the seller and the listing agent are in contradiction. And so the buyer is not protected. Remember that you represent the buyer, you are not the buyer. You represent the seller, you are not the seller. You cannot make decisions for them. The decisions should be made by the buyer and the seller in writing.
Absolutely. This is real estate. There are no verbal agreements. Everything has to be in writing and signed by each party. So that's the only way that these things are enforceable.
Another change is what Nelson mentioned about the buyer staying silent. Okay, the seller can cancel on them. And now, if you move forward, there is a provision that automatically converts this to a cash transaction.
Right. So what I was saying before, that if the buyer never communicates that they were unable to obtain the loan approval period, and assuming the seller does not cancel the transaction, it is now considered a cash transaction. You are no longer protected by the financing contingency, and you will proceed to lose the deposit if you're unable to close through no fault of the seller.
So now there's additional changes, right, that we have to talk about. Nelson mentioned the appraisal is explicitly excluded from property related conditions. And now the appraisal needs to be done during the loan approval period. This is absolutely important because before, the buyer had the entire length of the contract for the appraisal, and many realtors would ask why there was a rider for the appraisal contingency if the base contract was already contingent to appraisal. And one of the reasons is that that appraisal contingency addendum actually did have a time frame. Now the time frame to do the appraisal is being incorporated into the base as is contract. And what is the expectation is that fewer contracts are going to fail to close later in the period. In other words, I think the Association of Realtors, for the benefit of all realtors, buyers, sellers, and lenders, wants to promote that if there are property-related conditions, such as the appraisal, that do not meet the terms of the financing, that we find out earlier so that the seller's properties are off the market as little time as possible.
Yeah, I mean, the way it used to be in theory is if you had a 60-day closing period and a 30-day financing period, you can cancel the deal on day 59 out of 60, even though your financing period was on day 30 because the appraisal came in bad. And again, I think this is going to help. I think it's going to help, set good and clear expectations for everybody involved. Buyers have to be on their toes. They have to be aware. They have to do everything on time. The lenders have to be on their toes. The buyer has to make sure that they've hired a good lender that can execute all of the things that they need to execute during that loan approval period. And the other caveat is, as a representative of buyers, you realtors have to understand what the timeframes are for your lenders to approve your buyer and to get that appraisal done, because that's going to be the amount of time that you're going to put in the loan approval period when you make the initial offer. If your lender that you're working with needs 45 days, don't put a 30-day financing period. If you feel comfortable with the amount of time that it's going to take your lender to get this approved and get this appraised, that's that amount of time that you're comfortable with, that's what you need to put into your contract.
Two of the most frequently asked questions that I get are around this issue. One is, how long should I make my loan approval period for? That question really should be a discussion between you, the realtor, the buyer, and the lender.
Correct.
Okay, the lender should indicate to you how much time they feel they need. And the loan approval period is considered by many to be part of the attractiveness of the offer. A shorter loan approval period, it could be more attractive when you're trying to win a transaction. Now, we deal with a lot of foreign investors who are getting loans at great rates to come and invest in the United States. But foreign investor loans, for example, take much longer to get approved.
Yeah.
You cannot expect to try and win a transaction with a 21-day loan approval period, where maybe you would use that for a first-time home buyer that's already been pre-approved, already has all their conditions met, all their documentation met. This other person is starting, they came to Disney World with their family, they stopped by a lender's office to talk to them. They haven't even started. If you throw a 21-day loan approval, now they're not going to be protected. And one of the most frequently asked questions I get from the buyers are, I want to make sure if the appraisal does not come through, then my deposit is going to be protected. That is still part of the contract, but now it's part of the conditions that must be cleared during the loan approval period.
Yeah. As our lender friends will say, there's borrowers and then there's borrowers, right? There's borrowers that are W-2, that everything's kind of squeaky clean, all the boxes are checked, and they're very basic to get approved. And there's borrowers that you need some time to get them approved. It's not that it can't be done, but it may take 45 days to get them approved.
I'm sorry about this floating bar. I haven't found a way to take it off. So if it's annoying you, it's also annoying me. So I apologize. So anyway, as you've seen in most of the slides, we've sourced a lot of this information. We've gone to a lot of these trainings. We've been trained, by the Florida Realtors Association that does a phenomenal job at training. Our underwriter, which is Attorney's Title, the fund, they do a great job of getting materials to us from an attorney's perspective. And so we thought we would, use some of the fund's materials to summarize the importance of the financing paragraph,
Yeah, and again, one of the important points I think is that second point, give timely written notice of intent to proceed regardless of loan approval. That's if you want to move forward. Silence, as you can see later on, equals that it's either a cash deal or the seller can terminate. So communication is key prior to the end of that loan approval period. Just trying to reiterate that point.
All of you, if you signed up or you're joining us through the live stream, we created this presentation so that it could be shared. It's going to be up on our social media. Share it with your clients. I tried to write it with Nelson in a way that was easy to understand, plain English, and that you guys could read through it when we're done. So now let's go to the next topic, which is closing and closing costs. Paragraph 4 has a change that for us is very important as closing agents, because as many of you who have been part of closings may have experienced, especially on Fridays at 4:59 p.m., it's very, very stressful because funding windows are closing and buyers are outside the office with their moving truck and they don't have the keys to their house yet because we either have not received funds or we have not received documents. Can you talk a little bit about this?
Yeah, I mean, look, our central role as a closing agent is to protect really the transaction in this regard. We are supposed to receive all of the documents and we're supposed to receive all of the money. And once we have all of these things and everything's, all the conditions have been met, once we have all those things, that's when we can disperse. And, dispersing before that does not protect the buyer, does not protect the lender. Because, there may be conditions left and you can't really do that. You're holding these funds in escrow until all conditions from the seller side have been met. Same thing happens with the seller. The seller gives me all their documents. They don't want me to do anything with their documents unless I have all the money from the buyer. So there's also a protection to the seller. That's why we get used, because we're an independent third party that we make sure that everything is done before the final, funding of the transaction. And once all those conditions have met, I declare the transaction as, ready to fund. And once it's ready to fund, possession can be given. Now, funds collected, that doesn't mean checks, that doesn't mean anything. That only really means wire transfers, because any other method of payment can be reversed. And so ACH payments can be reversed, checks can be reversed, cashier's checks can be reversed, money orders can be reversed. So we really can't accept other methods of payment. We only accept wire transfers. And then as far as the documents are concerned, I really can't do anything with scanned copies of documents. Because I'm not allowed to record scanned copies of documents. I can only record documents when I have an original in my possession. So, that's really an important consideration. A lot of people think, oh, you have a copy of the deed, you should be able to, fund. No, that's not the case. I'm not allowed to record if I don't have an original.
This is another place where you as realtors, mortgage brokers, you guys play a super fundamental role in helping shape expectations for the parties involved. Everybody wants to close. We want to close. The bank wants to close. We gain nothing holding back a transaction. We have a responsibility to the parties to execute the contract. And your role in creating expectations will determine the ultimate level of stress that is involved in closing. If you represent buyers, it is important that they understand that the keys will be turned over once we can show that we're ready to fund, and that, but many sellers say, oh, I'm not going to give you the keys until I have the money in my account. And that's just not how it should work. So I think the realtors also need to coordinate amongst themselves and make sure you guys are on the same page. If you're dealing with customers, foreign customers, either sellers or buyers, The role of the closing agent as intermediary really does not exist formally in most other countries. There is an attorney that sits with the buyer and the seller across the table from each other. They're usually sharing, coffee if you're in Latin America, or vodka if you're in Russia, whatever the ceremonious, situation may be. And they're closing the deal together. Here we have requirements to meet. Okay, so I encourage you all to reach out to us as closing agent when we're involved in your transactions. We have instituted two important phone calls with you and clients that we feel have significantly improved the expectations of the client. The first phone call is called the onboarding phone call. It's a simple phone call where we just walk them through and allow them to ask out loud questions which are going to be based on their assumptions. If they've never done this before, they don't really know what to expect. And so let's just get it out there. Let them ask the questions. They're going to express their fears, their doubts, and this is what we're here for. The other is a pre-closing call. The pre-closing call usually happens about a week before the closing. This is when the client is thinking about, when do I send the money? How do I send the money? When am I going to get the keys? And in this pre-closing call, one of the areas that I have most picked up on is the buyers that have the moving truck ready to pick up their things at 7 a.m. on closing day. I cannot tell you how many things are out of everybody's control so that if they have the moving truck at 7 a.m. outside their house, the probabilities of disappointment are very high. So the reason I tell you this is not to lower anybody's standards of how closing should happen. It's actually to elevate everybody's expectation in conjunction with each other, because we are all on the same team.
Yeah, and again, there's a lot of moving parts to a closing, and the buyer, for example, stuff that's within their control that can help a situation like this out. If you're getting a loan, close early, and it's not necessarily in their control, because sometimes that's dependent on the lender. But if you have an option of closing at 11 a.m. on the closing day, or at 3 p.m. on a closing day, your chances of funding on the same day is much higher at 11 a.m. than at 3 p.m. A lot of things can happen after 3 p.m. that is outside of everybody's control, and then the deal doesn't fund, and we move into Monday. Just last Friday, this is the late closing. We're getting ready to fund a transaction at 5 o'clock. Our office building was evacuated by the SWAT team of Miami-Dade County, and we had to get out, and we couldn't finish our work. It was, I've been doing this for 21 years. I've never experienced that in my life. But it's just one of those things that happen. And unfortunately, we had, a family waiting to get their keys, and we were unable to close the deal on an emergency basis. Again, it was outside of our control. Many other things that can happen in those situations is we're waiting for the lender to give us approval for funding. And sometimes we've given everything to the lender, and the lender takes hours to approve it. And then by that time, you're outside of your wire transfer window, and you can't send a wire transfer to the seller. And again, that'll cause a delay. So if you can make a choice, and if something's within your power to close earlier, please take that opportunity.
And we'll talk a little bit more about time, because there's an important change
Yes.
for the time provision, right? So going back to the closing costs, I just summarized some of the easier to understand changes. For example, if there's a FERPTA withholding for the seller obviously has to pay related charges. There are usually usually additional withholding expenses that the seller needs to account for, in addition to the accountant expenses, etc. There's a change in that the seller is expressly responsible for providing existing owners policies to buyers. Okay, that's an additional change, very simple to understand. In the Miami-Dade Broward regional provision, they added a line that explicitly states that the buyer chooses the closing agent.
Yeah, these are all kind of items that were understood previously, but not explicitly stated. So again, they're trying to clarify things, although this is the way we've always kind of operated for all of these years. But these are just things now that are expressly stated and much simpler. I think we can
Yeah,
move on.
the one big change that you must know is that the survey now has a time frame.
Yeah.
There's an explicit requirement for the survey to be delivered at least 5 days prior to closing. Another change is that if the seller is paying the liens imposed by a public body, there are several liens where prepayment is not permitted. And the clause before said, seller shall prepay all liens imposed by public body. One of the provisions of the contract that generates most confusion. Now it explicitly clarifies that if you cannot prepay it, it needs to be prorated. They're also including a clarification on the special assessments imposed by a special district, that they're going to be prorated, just like the CDDs are going to be prorated. Those are in the non-ad valorem taxes as well.
Yeah, and again, that's how we've been doing it in the past. When we prorate, they're prorated in the same fashion. It's just clarifying the items.
Another of the more common misinterpretations of the contract is paragraph 5 and the automatic extension of the closing date. This paragraph, I feel, Nelson, has been abused by many people in different circumstances. Can you explain the gist of the paragraph and the changes?
Sure. I mean, there's a under the CFPB that passed a few years ago, there was a requirement to disclose the closing costs to the buyer a certain amount of time prior to closing. And so what this paragraph said, it was basically, look, if the disclosure happens at a time, to the buyer that doesn't allow enough time before the closing date, then the closing date is automatically extended to allow that time to pass.
Yeah.
And so if the CD, let's say the closing date was, January 10th, and the CD, the closing costs were disclosed to the buyer on January 10th, which is the same day of closing, we needed to wait at least 3 business days before we can close. And so this paragraph, became an automatic extension for that purpose. There was a little bit of, I guess, abuse, some things that obviously these governing bodies saw that they wanted to address. And so now, I guess sometimes people were using that for a loan approval. And so now it's very clear that this will only be extended if the loan has already been approved and the underwriting is complete. So they're adding conditions before we can use this paragraph on the extension. They've also, lowered the time frame from 10 to 7 days. And so therefore, again, right now, the lender has to, if we're going to use this paragraph, has to say, hey, look, the loan is approved, the underwriting is complete. All we need is the time frame to pass so that we can get to closing. Then we can use this paragraph.
I have been part of so many phone calls with lenders, with buyers agents saying, don't worry, we have an automatic extension because the clear to close has not been issued by the day of closing.
And that's not what that was not the spirit of the.
Right. If you do not have the clear to close by the closing date, your buyer will very likely go into default because there will not be enough time to close that unless you have negotiated an extension, in that case, of the closing.
Yeah.
Okay, so this is an important change. Okay. Personal property and collected funds, technology changes. We have electric Nest thermostats that are worth hundreds of dollars. We have Ring doorbells, TVs all go on the walls, etc. So they have updated with more personal property. I still have intercoms on my house, even though they don't work, but they are now deleted from the paragraph on personal property. Here they take some time to continue to clarify the standard S of the collected funds. I think we already spoke about this.
Yeah.
In assignability, very simply, now it says if no box is checked, the buyer may not assign.
So it's very important because if you want to, we do a lot of transactions with investors that want to have like an LLC or whatever entity owning the property, but they may not have the LLC form when they sign the contract. It might be in their individual name. So if that's the case, you're probably going to want to check off the middle box, which is may assign but not be released. Probably many sellers won't allow you to do the first box, which is may assign and be released. So that's something to consider. If you have a buyer that is looking to, form a company or change the structure of how they're gonna buy the property and that is not listed as the buyer on the contract, we should check off that middle box.
Some changes to permits disclosures. There's language that was added referencing some amendments that allows for additional methods to satisfy open or expired permits. I think that's more a case by case going through, what happens in certain situations. But essentially, the base of the contract says that the seller does not know of any improvements made to the property which were made without required permits or pursuant to permits which haven't been closed. If you happen to purchase a property if you're selling a property where the previous owner did changes without permits and you know about it, theoretically, you should disclose them.
Yes, absolutely. More disclosure protects the seller from any liability or any ability for the buyer to get out of a deal. If you've disclosed it, you should be covered. If you don't disclose it, then, the buyer has some ability to potentially, have some kind of claim against you or cancel the deal. And maybe that's not something that you want. So if you disclose it, you'll be covered.
Some changes to paragraph 11 on property maintenance. This new language in paragraph 11 wasn't present before, but it was already referred to the procedure of how we would escrow funds in paragraph 9. But this additional language basically says that seller can escrow amounts to cover maintenance costs if the property hasn't been maintained before closing.
Yeah, basically, this is very rare that this provision is used, but, the seller has a duty to maintain the property in the same condition from the day of the contract to the day of closing. If there's a change in the condition, if now there's a hole in the wall that wasn't there before, this allows us to have some escrow and to cover any kind of damage.
Now that you bring it up, this generates a lot of stress when the property either has a tenant or when there's a post-closing occupancy agreement, which has been very popular in the last 8 months of the hot market, where a seller is selling their property, but they don't have where to move. So they need 30, 60 days post-closing to occupy the property. When you do the final walkthrough before the closing, all the artwork is still up on the walls and the TVs are all installed on the walls. Then they leave 45 days later and they have all these holes and they have all this maintenance to do, right?
Well, I mean, if you're gonna have a post-closing occupancy agreement and that's the kind of stuff that you're worried about, then you should negotiate a security deposit.
Absolutely. Or explicitly state that, that the seller and then the tenant or whatever it's called in the post-closing occupancy agreement has a certain duty to, cover the walls or
Correct.
paint the wall or whatever.
And ultimately, all you can do is put some money aside to protect the buyer. That's really the only option the buyer has in those situations.
Right. And in this market, it's been very complex because, the sellers feel like they have all the power. So they say, no, I'm not giving you any security deposit. And
Well,
so the buyer is completely unprotected.
Unprotected, and the seller leaves a hole in the wall, and basically it's on the buyer to take care of it. I don't think something like that is probably worth going after the seller.
Yeah.
But that's really what the security deposits are for.
Some of the more important changes to the contract, to this revision that go into place on Monday, November 1st, happen in the title standard, right? These are definitions related to title. So we're going to go through some of these. The first one is time. The changes now include that time is based on the property location. This seems obvious maybe to some of us, but there has been a big trend in the last couple of years amongst many lenders who have started setting up processing operations on both coasts. So lenders who are in Eastern Standard Time essentially gain time by processing on the West Coast. But if you provide any kind of, let's say, lender authorization at 4:59 in California time, that is way past the closing window in US time. So now they have explicitly said that time is of the essence and it is based on where the property is located. So that would mean East Coast time for Florida.
Yeah, and it not only happens at the end of the day when it's a problem, but it also happens at the beginning of the day, because when we're in the office at 9 a.m., it's obviously 6 a.m. in California. They're not working. We don't hear from them till noon. and we're trying to close a deal Friday afternoon and get that buyer in there, and they got a West Coast lender processing their deal, we're not even gonna start hearing from the lender till afternoon.
Right.
And so that could be a very late closing, and again, that creates more of a probability that we're not gonna fund on the same day because of the time difference.
I know that with a lot of our lender friends, loan originators and mortgage brokers, this generates an enormous amount of stress for them because it's completely out of their control.
Yeah.
They have no control if some of these huge lender operations are in the West Coast and the realtor and the buyers are calling, we're calling, and the increase in the number of calls does not accelerate the transaction
Yeah.
when something is out of your control. They also eliminated the 5 p.m. The 5 p.m. reference, which our underwriters and us, Nelson and I, we were a little bit perplexed.
Yeah, I mean, it's a little, a business day, I guess, is undefined in this contract. Does it end at 5? Does it end at 6? It's kind of hard. I mean, I know of a lot of people that have wire cutoff times at 2 p.m. And so, I don't really know how something like that gets defined, but, I would and again, this is just an assumption of mine. I would assume a business day ends, let's say, at 6 p.m. But a lot of people assume it's at 5 p.m., which is perfectly reasonable as well. But there's really no definition per se.
We don't know why they eliminated it. Maybe we can reach out to the committee and find out what they were thinking with this one. Force majeure gets redefined. Talk to me a little bit about force majeure.
Yeah, I mean, we're adding some, civil unrest, which we saw a lot of last year. Obviously, epidemics, pandemics, we saw obviously a lot of that. That has to do with government actions, mandates, shutdowns. All of these things were kind of, new to us in the last year, and so they've just added some of that to the language. Again, many of us assumed that a pandemic was a force majeure because it was actually out of everybody's control, and we weren't able to do certain things by certain times. And this allows us more time to perform contractual, duties. Again, to me, it's obvious, but again, it is subject to abuse.
Yeah.
I saw a lot of that last year as well. People trying to get out of deals when they didn't really necessarily have a leg to stand on.
Yeah, I mean, with hurricanes specifically, which affects South Florida, if you don't already know, when South Florida is in the cone of danger, insurance markets shut down, and so some transactions cannot physically close, even though we're all ready, because the insurance cannot be bound before the closing, and so it stops the closing.
Yeah, and the insurance begets the loan, and the loan begets the closing. So you have this chain reaction. The lender's not going to lend without insurance, and so on and so forth. So
closing location for the FinCEN requirement. If you didn't already know, there is a government agency called FinCEN, which in certain geographic areas requires that when a transaction is done in cash by a legal entity, okay, that
in excess of
$300,000, the closing agent has the obligation to provide the federal government with information about the beneficiaries, the individual beneficiaries of the buyer, okay? And now the contract is essentially clarifying that it is in fact an obligation. So for all of you who are working with legal entities, LLCs, corporations, who are buying properties above $300,000 in cash, you must know that they will need to disclose an important amount of personal information that is a condition of closing.
Yeah, and it's very simple. We provide forms. The forms are filled out. We submit it to the government, and then we're done. But basically, at this point, I think most people know about this. And if they don't, this is, it's just a government rule. We can't. It's really black and white. We can't proceed to close without this information.
This is another one of those setting expectations pieces for your foreign clients,
foreign buyers, and really domestic buyers too, because it can apply to them. Moving on, we talked a little bit about the prorations already. We can go to deliveries. I think this is a very important change. A lot of realtors obviously have an extensive amount of communication by text message. And some realtors I've seen, are under the impression that text messages create a legal obligation under the contract. Oh, the listing agent told me that they were going to fix this problem, and now they're not fixing this problem. And then they point to a text that they have. A text is not an addendum. A text is not something signed by the buyer and seller. So that's one thing. The other thing is delivering notice. And this is where this change comes in and becomes very important. We had a case recently within the last couple months where notice cannot be provided by text, and somebody tried to give notice by text, but that's not a valid form of notice. Really, the valid forms of notice are either email, obviously in writing, by FedEx, courier,
Certified mail,
a fax, a facsimile, for those of you that still use fax. There's certain things that we can still deliver certain notices on, but we cannot use text messaging for that. And one of the notices that we talked about earlier today that's extremely important to be delivered on a timely basis is the ability to either move forward or cancel a deal under the financing contingency, or it could be the due diligence period, where the buyer has elected to cancel the deal. If the buyer elects not to cancel the deal, no notice has to be given. But if the buyer wants to cancel the deal after the inspection, they have to provide a written notice, and it has to be done in person, mail, email, or fax only, not by text. And that's very important for the realtors, because a lot of times the realtors are the ones caught up in this kind of communication. And so again, very important for our day-to-day practical.
right? And just to add to this, I interact all day with realtors, as many of you know, and I have come across many times realtors whose primary language is not in English, and they're dealing maybe with a realtor listing agent who does not speak Spanish. This is not an excuse for not putting things in writing. Okay, if you need help, say something, because it has to be delivered in writing. When we represent a seller, if there is a notice that must be given to the closing agent, we will write an email and ensure that it gets put in writing if we're made aware that something has to be put in writing. For example, if the seller is going to exercise their right to cancel the contract because they didn't receive notice that the buyer was moving forward with a loan, or not moving forward.
Yeah, the silence, what we talked about earlier on the silence provision, this is the only time that the seller has an ability to cancel a deal. Otherwise, the seller can never cancel a transaction unless the buyer defaults. That's really the only option.
Before I move on, Nelson, one of our questions from the audience was to explain these prorations. So I just want to really quickly go through them. First, you have these prorations that we're talking about are not special assessments of condos.
Correct.
These are special assessments imposed by public body, municipalities, cities, counties, the government. Okay, there are certain special assessments that are imposed that can be found usually in the non-ad valorem tax assessments. What this is referring to is there are now things called CDDs, and there are other community assessments, right? That the changes that are being made clarify that that those will be prorated similar to other non-ad valorem assessments.
Which again, for the most part, that's always been the case. That's how we've always done it. So really not a lot's going to change from a practical point of view. Most of those types of things are not something that we can pay off. And so simply we just prorate it amongst the parties.
Right.
And these special district assessments, which are very different than special assessments from an association. These are normally, again, collected through taxes. This is it's in your annual tax bill, and they get prorated just like the property taxes do. They're sometimes on a different schedule than the property taxes, but they're still collected once a year in the property tax bill, and we prorate them at closing. So really, there's not a big change
Right. Right.
here,
Just
from
as-
our point of view.
Just this morning, as I was preparing for this presentation, I got a text message from one of our realtors because their buyer was upset because the non-ad valorem assessments are calculated on a different schedule. So the seller, the buyer felt was only paying 1 month of special assessment, and it's really just because
It's
the way
just
the
the-
calendar.
It's just the timing of it.
Exactly.
A lot of special assessments are collected from October 1st of any given year through September 30th. The property taxes are collected on a January to December
Right.
timeframe. So you have different timeframes. One is paid in arrears, one is paid in advance. So that's a question of fact. It's a very black and white issue,
Yeah.
and obviously I'd be happy to help anybody understand.
I'm gonna skip ahead to this new rider because this new rider has to do with PACE loans.
Yeah.
It has to do with loans for energy efficiency, like, impact windows and new roofs that you can get through these special PACE loans. And I want to tie it into the operations because these come out in the non-ad valorem taxes as well. But this is very, very important to understand that it is a mortgage on the property. There is a lien on the property. This isn't a proration that gets done.
No.
The change that is made, in my personal view, I am not an attorney, I do not play one on TV. My personal view is that the changes made are a little bit less than I would have liked, because all it says is it discloses that most lenders will require a satisfaction or release of the PACE financing from the property. But I can tell you, as closing agents, we need to satisfy that PACE loan, because otherwise you cannot get a new mortgage, because this mortgage would be in front of the new mortgage.
Yeah, so basically every mortgage lender that's going to come in and help a buyer buy a property, they want to be in first position. And this PACE loan is really in first position. And so they won't give you the loan at that level. And so the loan has to be paid off. A lot of sellers were sold the idea that, hey, this is collected in your property taxes. Any buyer in the future can assume it and they'll pay it in their taxes. And that's really, unfortunate, because, I've heard that from many people.
Well, and it says it in the documentation of many of these PACE loans that the loan is assumable. What it does not tell
It's
you
assumable.
is
Yeah.
that the new lender
Right.
will allow it, because it would essentially put at risk the
Yeah.
new mortgage's position.
It's assumable, if the buyer allows it, and if the buyer is really not obtaining a loan. So like if the buyer is paying cash and wants to assume that loan, then
it's assumable.
the buyer can make that choice and continue
Right.
making those payments. But yeah, and from a practical point of view, most buyers get loans and they have to be paid off. So that's caused a lot of stress in certain transactions between buyer and sellers. A lot of sellers have argued that this is not something that needs to be paid off and is not a lien. I've actually heard that from attorneys, and it's mind blowing to me, but.
Right, so I wanted to tie it into the prorations, because the prorations were referring to non-ad valorem assessments. These PACE loans are usually put into the non-ad valorem assessments. Those do not get prorated. They must be paid off at contract. So flying through the riders, some of the new riders, there is just, some additional clarifications in the FHA VA rider. They created a new mold inspection rider, but that is not for the as-is contract. It's for other association contracts. They've allowed for pre-closing and post-closing occupancy agreements to permit agreements that are not just written leases. I don't know exactly what it would be. I think I would feel more comfortable with a post-closing occupancy agreement that is sort of looks like a lease and talks like a lease and sounds like a lease in many ways.
Yeah, my recommendation on these pre and post-closing agreements are that the actual form get agreed to at the contract. And that way there's no kind of discussion later on. It just makes things smoother down the line, and that's my recommendation, if possible.
We already spoke of the sale of buyer's property contingency. The backup contracts are now requiring a notice of termination in writing, and the disclosure of the backup offer parties must be stricken and must be removed. There's this last addenda that was created, the seasonal and vacation rentals after closing, which I think is a sign of the times of Airbnb properties, etc., where they are basically allowing the seller to disclose whether the rental terms are going to need to be approved by the buyer if they get under such terms. Many times you have a short-term property under contract, and they already have a future number of bookings on Airbnb, right? And so the buyers want to know that.
Yeah, no, and if you've already got bookings set up, then obviously the seller will have to make reference to that in the contract. The buyer will have to honor them. But basically what this says is that no additional ones can be done unless either one of the two boxes, we get a buyer's approval or we don't get a buyer's approval, but that's a negotiated point between the parties.
So basically, to summarize, you guys are going to get copies of this presentation. This summary is basically was provided or was facilitated by Attorneys Title Fund Services. So they did a great job. We're talking about paragraph 1, personal property, paragraph 4, how the closing is defined, paragraph 5, the CFPB provision is much clearer. The change in the assignability. The changes in paragraph 8 are extensive and important. Changes in paragraph 9, the changes in the standards and the riders. So in two short slides, you kind of have it all summarized.
Yeah, I think the summary's there. You're welcome to review that later when you see the slides. Probably at this point, we'll want to open the floor to questions. We're going to go into the chat and see what questions you guys have and go through them.
So one question from Pablo Martinez is asking about the 3-day waiting period on investment properties. Pablo, not all kinds of loans require the 3-day provision. It really depends on the type of loan, and there are many investor loans where this provision would not apply.
That's correct. The provisions of the CFPB that we were discussing earlier today that had that automatic extension of the loan is really focused on the residential,
Federally backed.
single family home type of deals. It doesn't have to be federally backed, but it it basically for residential purposes for people that are occupying their property.
But for example, non-QM loans, I believe, don't have a 3-day right of notice, right? A question from Carolina is with the change with the survey, what happens if the survey is not ready 5 days prior to closing?
Well, that's a problem. Potentially, and again, the problems happen when there's an issue with the survey. Now, obviously, if the survey is okay, there is no problem. But number one, you're going to need a survey to get your loan. So the survey should be done, before that. However, if the survey is not ready 5 days before, and then you discover a problem with the survey, and you haven't done it on a timely basis, as a buyer, you basically waived your right to create a title defect issue, because the way the survey works is really a defect on the property. And if there's, let's say, a pool built inside of an easement or some major problem like that can cost your buyer $70,000 or $60,000 or however much it would cost to move a pool or to remedy that situation. Those are big problems that can be discovered. So if you don't do it on a timely basis, you're not protected.
So, as the questions come in, I mean, we have all sorts of services for all of you, residential, commercial closings. We do a ton of international closings and international remote online notarizations, a lot of expertise on FERPTA and 1031 exchanges, as well as escrow account management. We know that several of you have brokers who don't accept rental escrows. We're starting to expand our services into that. Please visit our website, which has a ton of great resources, including a video library. We're about to launch our online automated quoting system. You can submit contracts through here, and you can share this with your clients in different languages, Spanish, Portuguese, as a resource. And one of the things that you want to point out to your clients is who we serve and some of the expertise that we have. We're talking about realtors and brokers, which we collaborate extremely closely with, in addition to buyers, sellers, internationals. Many of you have sold properties whose clients reach out to you for refinancing. Those refinancings require a closing. Please let us know, and we're happy to facilitate that refinance closing. And with our mortgage brokers and lenders, we have extensive partnerships. We work with hundreds of mortgage brokers and lenders, and we're always looking to work for more. So, if you have any questions, please continue. We'll keep the chat box open, but Nelson, any parting thoughts?
No,
How do you feel about these changes as an attorney?
I think they're positive. I think they set clear expectations. I think there should be better clarity amongst the parties about how things will work moving forward. And again, I think that just only helps everybody.
From my point of view, I also agree that these are very positive changes, and not to beat a dead horse, but so much of the realtor's value added is creating expectation. You do not have to sound like an attorney to provide expectations to your clients based on what these changes say. What you do have to do is you have to learn about the contract, right? You don't have to give them a legal opinion to tell them that they need to comply with the time frame. So the way that you set up expectations, I'm a firm believer that happiness and satisfaction is the difference between expectations and reality. If you're able to bring those expectations more in line with the reality, I think we're going to have smoother, more pleasant transactions with less amount of stress. And if we can help in any way, shape, or form to set some of these expectations with your clients, please let us know. All right.
Yeah, thank you so much.
Thank you all for joining. For all those that live stream, thank you so much. Please reach out to us. We are at FOLIO Title on Instagram, at FOLIO Title on Facebook. And I will leave for you our contact information so that if you want to email us, call us, my cell phone will be right on the screen. And good luck, everybody. The next couple of months are going to be intense. Start getting ready for the new year, and don't, if you're going to enjoy the holidays like most of us, and make sure that you start setting up your base for January, February, and March so that we can start the year off right. All right.
What a plan.
All right. Good
Yes,
luck,
guys.
everybody. Thank
Bye-bye.
you.
Thank you.
Bye.